Peace, everyone. Peace, everyone. How's everybody doing today? 1 second. I'll be right back. Y'all hold it right there. Sorry about that. I had to get my water. Let me try to put this on Do Not Disturb, because this is going to be a good show today. I see we got Juan Galt in the audience, so I got to be on my P's and Q's. I have to be on my P's and Q's. I am Mr. Galt. I'm actually, that ain't your real name, Mr. Galt. But I'm actually looking for some feedback on this. I've been doing some research on this. And where is this thing at? Oh, here it is right here. All right. Okay, everyone. Here's the deal. I've been doing a lot of research. Everybody in this space, they want to say they have these opinions about what jurisdiction the courts are operating under. And I'm going to tell you my position of where I started from with all of this, and the research I've conducted. And my research is not being conducted from anything coming out of an echo chamber. I've been using the analysis and interpretation of the Constitution by the Supreme Court, and I found a law review. And of course, I've been using the AIs to synthesize the information and kind of analyze, kind of juxtapose it with my view of what is going on. And I'm going to let y'all actually see the conversations I've been having with the AIs on all of this. But I kind of want to establish a foundation of my approach to doing the research. That has been my contention that U.S. district courts are not Article III courts, and that the Judiciary Act could not have created Article III courts pursuant to, the doctrine of separation of powers. They weren't vested with the judicial power. They can't delegate judicial power, and they can't exercise judicial power. And when the courts are enforcing a statute, because they have original jurisdiction and appellate jurisdiction, I understand that if somebody's freedom is in question, how that would subject them to the appellate jurisdiction of some sort of judicial review of any processes that they have conducted, by the Supreme Court or Article III courts. They're going to have, there's going to be some sort of constitutional authority, and somewhere in that chain that's going to have the ultimate decision over all of that process. Now, I was also doing some research on this Jarsky case with the Dodd-Frank Act, the Frank-Dodd Act, and the argument they were having with the SEC operating, almost exclusively exercising, looking like some sort of appellate plenary power within their cognizance. And I understand it also because it's a commercial matter. They have the right to regulate commerce under Article 1, Section 8, Clause 3, which is the Commerce Clause. And I can understand why they could make that argument. I can understand a lot of the arguments that the federal government makes. But there's something that nobody has been able to just convince me about these courts and these enforcing statutes. Not to say that that statutes are unlawful. I'm not making an argument. Those are dumb sovereign citizen arguments. I'm a little smarter than that, saying that they're unlawful. However, wait a minute. Okay, that's not true, DeJuan Galt, because I found out recently that Congress gave their administrators the judge, just because the judge is operating lifetime tenure and with salary protection against salary diminution, that argument, I think that that's a tactic that is being used to obfuscate the issue. That's my argument. It's like, okay, well, these judges, we have clothed them with lifetime tenure and protection against salary diminution. Okay, granted. All right, but who gave them that power? The Congress gave them that power. Congress gave administrators that same protection, but the Constitution gives the Supreme Court justices that protection. Therein lies the difference. One has been given that power by an authority that doesn't have judicial authority, which is Congress, and the other is given by the Constitution. Now, that right there, when they started doing that, because I was reading about that, when they started giving administrators this protection against salary diminution and lifetime tenure, well, that doesn't change the nature of the office. It's still an administrative law judge. So that doesn't make any. I've seen that argument, and we can argue that point if you want to, because I don't agree with that at all. If they are enforcing a statute that's been promulgated by Congress, okay, that's a political question, okay, and that falls outside the cognizance of Article 3. No, let me take that back. It falls within their appellate, their appellate oversight of Article 3. But I don't think just because they have lifetime tenure and protection against salary diminution, because I understand why they have that. That's just so they can make sure that they are unbiased. No one can come and exercise any influence over the judges. But do I need to show you all of these? I can show you many different videos on YouTube where they're bringing administrative law judges into court, and the senators are just blasting them. But when a real Article 3 judge comes in, as in the case when Breyer and Judge Breyer and Scalia, in that video, the role of the Supreme Court under the Constitution, totally different, level of respect they're demonstrating to those justices. So are you saying that, okay, I can see how, okay, you can have an Article 3 judge, but if it is adjudicating statutes, are you saying it's operating in an Article 3 capacity? If like on the U.S. District Court level, those are Article 3 judges. Are they operating in that capacity as an Article 3 judge? I'm not questioning whether or not they're an Article 3 judge. I'm questioning whether or not, when they're enforcing a statute, whether or not they're operating in an Article 3 capacity. That's my question. So let me just show you what I've been looking at. I have, let me see. Screen capture. Let me see if I can pull this up. Okay, when I was reading this law review, hold on, I didn't get a chance to set up my my screen. I got all my documents out, but I didn't get a chance to set up my screen. What's happening right here? Oh, okay. it's a trip, man. When I get ready to do something, the computer start doing something it's never done before at the most inopportune time. It's like Murphy's Law is real. It's like whenever something can happen, it will happen at the most inopportune time. This thing is never, I've never had it do what it's doing right now. You know what? Let me just delete that. All right, so where's the screen capture? All right, all right. So I'm gonna start right here. This was a University of Pennsylvania law review. Okay, founded in 1850, formerly American Law Registry. This is a colloquy of the Article 3 and the Judiciary Act of 1789, the two-tiered structure of the Judiciary Act of 1789 by Akhil Reed Amar. And how I found this because I was actually reading analysis and interpretation of the U.S. Constitution, as you can see here, and because I was hunting down this footnote where Justice John Jay and George Washington, they were having a discussion about all of this. Talking about the two offices were incompatible. How is a justice going to wear two hats? He says, yes, when they adjudicate a statute, they're exercising Article 3 powers. This is noted in Section 2 when it refers to the laws of the United States, which are statutes. Okay, so then how does that conflate with the political question doctrine? How is that, when the judges say it's not a justiciable issue, okay, and they have to defer to those courts? Explain that to me in light of that. Hold on, let me, that's what I'm trying, because we got delegation of powers doctrine where I've read many law reviews where Congress can delegate some of their power to the Article 3 judges in the case of when they make a commission. And that's what Scalia was arguing. He's saying he didn't feel like that was constitutional for Congress to make a commission so they could decide, because he's sentencing guidelines, so they could decide how much time people are going to. You want me to play that for you real quick? Let me play that for you real quick. Let's play that real quick. Let's play that, because because I may be wrong. I may be wrong. Let's look at that. Okay, I'm sorry about that. I don't know what was just going on just then. Let me see if I can get this thing back on the screen though. Yeah, let me see if I can get this back on the screen. This is crazy, man. Like somebody don't want me talking about this. All right, so nah, I ain't gonna. Man, what happened to my? Okay, all right, there we go. All right, I'm sorry about this, y'all. I don't know what is going on. Let me see. I apologize for this. It's almost like this thing don't want to act right. Okay. All right, I got it. Forget it. We'll just do it like this. Okay, so apologize for all this, these technical difficulties. I don't know what is. I got like a new setup. I'm still trying to figure some things out with it. I'm in another studio, and I'm gonna have to do something about these this mouse and all of this. All right. So if you look on the screen, I spent a lot of time in this book. This is analysis and interpretation by the Supreme Court of the Constitution by the Supreme Court. I spent a lot of time in this researching because, you know, it's Article 1. Like if you go in this book and you go to Article 1, Section 8, Clause 9, there's nothing there. It's going to refer you to Article 1, Section 3, Clause 2, where, you know, it talks about, you know, and everything that the judicial power is delegated to the Supreme Court and anything, you know, Congress does. And I think people like to interpret that as, well, Congress can create Article 3 courts exercising some sort of judicial power. But in some kind of way, to me, that doesn't jive with separation of powers. And American Insurance versus Cantor, that judge, he gave it, he talked about that, as well as the original justices, John Jay, and a letter from George Washington to John Jay. He brought it up. He said, how are we going to wear two hats? Both of the offices are incompatible with each other. And that's where this delegation of powers doctrine stuff comes up. All right. So right here, I'm going to, let's look at this real quick. I want to look at this real quick. Let's revisit what Scalia was saying. I just felt like this conversation, it's the role of the Supreme Court under the Constitution. I've always found this video to be very interesting. Oops.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today.
Let me mute my mic.
Justice Scalia, I wanted to follow up on some things you had said in your opening statement. Along the line.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement. Along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce.
Okay, that is the key. Okay, these are dog breeding, because he brings up bicameral passage and they have to make presentment before the president. You know, this is how, you get a bill passed into a law. They didn't go through those channels. However, he gave a different scenario where they're exercising, you tell me if I'm right or not, Juan Galt, where they're exercising their constitutionally delegated authority under Article 1, Section 8, Clause 9, Clause 3, which is the Commerce Clause, which they exercise plenary power within that scope. And he makes sure he brings that point out, that now, of course, he's dog breeding, operating in commerce or some sort of channel or instrumentality of commerce. okay? And it may be antithetical to the Constitution. However, it's under our purview. We are able to do this. What type of role would you play in a situation like that? I think do I got it right? Or am I wrong on what they're talking about right now? I'm trying to follow along because I'm trying to see where my thinking is off, if it is off. You know, I've been looking at this and I'm trying to make sense of it because people want to call some of these people sovereign citizens. And granted, a lot of them, 98% of them do come into court saying dumb shit. I'm not challenging that. A lot of them do, you know, but that's just because 98% of them, they don't read anything. They're just in echo chambers listening to other people who don't know shit. They're not doing anything like this. They're not going to do a serious investigation of this and try to understand it, like through reading, actually reading the law or listening to actual authorities on the particular subject because they don't have any respect for them. And I see that. And their respect is due to the fact that there's a lot of stupidity and ignorance. And I'm trying to do my best to eliminate most of it. But I do still have some questions on some issues. Because I did go through some things dealing with these people, and I just had some things that I have to question. So let me get back to this. We don't live, but I just wanted to stop and point out to everybody what he just said. Now I'm going to replay this again. I want you to listen closely to what the senator says because he qualifies his question by impressing on the record that we're talking about commerce, interstate commerce, in which Congress exercises complete authority. Plenary means that they exercise all authority. Nobody can question it. It is completely under their power. Okay, so let me replay this again and listen closely. I know he hasn't touched Article 3 yet. I know I'm just setting it up. He's just discussing Article 1. Yeah, I know. I understand that one. He ain't said it yet. You got to understand, I got listeners. They not following, you know, I'm trying to put this in a way they can follow along because they may not be able to follow along with this, you know, but let's continue. I'm doing this for them, not you. I'm doing this for them. So let me start over. Y'all listen closely.
Certainly.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article 1, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. So let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce. But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the Board of Directors of the American Kennel Club. That passes both houses of Congress. It goes to the President. It's signed into law. And we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it. I didn't think that that was constitutional, so
Okay, my question to the attorneys out in the audience, why is this Supreme Court justice, and he was the one the dissenting vote, and he also ended up dead at Breyer's Ranch down in Texas. I thought that was mysterious. I'm sorry, I just thought that was very, very mysterious, but we're not discussing that right now. However, why do we have a Supreme Court justice who is looking at this, who also that you argued in front of, who also mentioned, he said, show us an example of anything that's been brought before us that has not been related to commerce. I read the transcript, okay? What I'm trying to understand, okay, why would he say that, number one? Okay, because I have the same questions about that as well. You know, he said make it more easier and more efficient. And it did, even though I took it through the bicameral process, made presentment, the president signed it over into law, but still he's going to get struck down because it does not comport with the Constitution. Okay, so I'm just wondering, I'm just bringing this to everybody's attention. Why is this justice saying that he didn't think this was constitutional? And now he's right now also, when I read in history, I just read in this right here where the justices were talking about, well, they would do it in the form of a commission, because this is a commission right here that the senators set up, and so they commission to them. It's like a delegation of power. Okay, I understand he's saying it's hypothetical. It's a hypothetical situation, but are you trying to say that there aren't situations that they delegate power? Because he doesn't like delegation of powers doctrine at all. Okay, so I know that they delegate power. They don't delegate their lawmaking power. They can't do that. But they delegate lawmaking. This is what they say to these agencies under the executive branch of government. And they do delegate power to judicial officials as well. I believe that's what this commission is all about. It's a delegation of power coming from the legislature. Is it not? Is it not? Do they not delegate some power to Article 3 justices? Is that not correct? Just curious. I'll let you type that up. I understand what it's saying. Congress wrongly delegated the legislative power in that dog breeding scenario. This is a hypothetical situation. I understand that. It is hypothetical. However, he's drawing a scenario that does have some real life examples. That's the reason he's making the hypothetical situation. So let's keep listening. I'll let you get your answer together. I'm keeping.
I am sure I wouldn't like your dog breeding body either. But I can't speak for the court. I don't know what the court would allow.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly. You have to be careful because John Jay, I just read this in John Stevens' book. It's pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer.
Okay, I had an opportunity to kind of investigate that using what Justice Breyer just said right here. And that's I don't think that is a very true statement that he just made. Okay, he refused to answer it. He did, but he did mention that the two offices are incompatible with each other. He said, how is the justice going to wear two hats? Okay, now I'm pulling it up right now because I'm on, you know, what he's talking about. They don't like John Jay, and they don't like any of the original Supreme Court justices, in my opinion, because of Chisholm versus Georgia and the decision in that particular case, that the American people are sovereign and they exercise their sovereignty independently instead of collectively, how it's being construed today through the organs and channels of government, through the electoral process. That right there, you know, I don't agree with that either. You know, how that right there. I think there has been, I'm going to tell you what I'm saying. I know the Marshall Court and all of that, and the 11th Amendment and the 9th Amendment, I understand all those arguments, but I think that this is where the conspiracy begins. I think that this goes all the way back then, that the American people need to examine those cases. I just think so. It's settled law. I will agree. Like I read the case law that you got, it is settled. However, he is saying that Congress wrongly delegated the legislature. Okay, rarely, if ever, Congress intrudes in SCOTUS processes. I'm not talking about. Okay, you think it's rare? I'm not really saying that they are. That's not my argument either. My argument is when I go into the court under the 6th Amendment, I have a right to know the true nature and cause of any action. And if I come into the courtroom and I'm asking the judges, okay, Your Honor, okay, is this civil or criminal? And I go into my little spiel and asking them what I'm trying to determine. I'm not trying to get the case dismissed. I'm trying to understand the true nature and cause of the action. And this is where it seems like a lot of obfuscating on this particular point. When you're on the record in court, this is what I have experienced. When you go in there and ask them these questions, they don't want to answer these questions. Okay, now they put a lot of fools on YouTube trying to do this thing, because that's the majority of them. They don't study anything. But that's my point right there. I'm not arguing whether or not they're exercising their rightful authority. Then they're enforcing statutes. But it's the nature of the action. Because now if I really understand, because it seems like they refuse to admit these are Article I courts. And if that is true, why? Would be my next question. Because now I got to go into Article I, Section 8 and look at the powers that have been delegated to them. And now begins that, you know, now we got to get into a question, how are you putting people in prison? These are some of the arguments that a lot of original, well, if you want to call them sovereign citizens, were making. And I think there is some substance to it. And there needs to be some clarification. You don't know, I don't know what constitutes nature and cause. Somebody give it to me. Tell me how do I figure that out? If I'm coming in, so what are you saying is when I come into the courtroom, I don't have a right to ask the question, because you can't just ask them, is this an Article I or Article III court? They'll start trying to charge you with contempt just for asking the question. They're not going to say it's Article III. They're going to start threatening you with contempt of court. I would like to read the case on the subject. And, you know, but I'm going to be honest with you. I'm going to read it, but I'm looking at the principle. How does this jive with separation of powers? That seems to be, because when we look at American Insurance Company versus Cantor, okay, that judge laid it all out. That they can, let's look at that real quick. I know this was dealing with a territorial situation, but the principle remains the same. This is the principle I'm looking at. I mean, American Insurance Company versus Cantor. Let me pull this up real quick. Let me look at this real quick. Let's look at this real quick. American Insurance Company. We'll get back to the video in just a second. Oh, it's American Insurance Company versus Cantor, Volume 26, U.S. Reporter, page 511, publishing date 1828. Let's look at it. It says, the Constitution of the United States confers absolutely on government of the Union the power of making war and of making treaties. Consequently, that government possesses the power of acquiring territory either by conquest or treaty. The usage of the word is, if a nation be not entirely subdued, to consider the holding of conquered territory as a mere military occupation until its fate shall be determined at the Treaty of Peace. Okay, that's cool. All right, I ain't going to that. The treaty with Spain. Let me get all the laws which are in foreign of Spain. Right down here, the laws of the United States, relative to the laws of the esteemed territory, the punishment. All right, right here. The Constitution and laws of the United States give jurisdiction to the district courts over all cases in admiralty, but jurisdiction over the cases does not constitute the case itself. The Constitution declares that the judicial power shall extend to all cases in law and equity arising under it, the laws of the United States and the treaties made or which shall be made under the authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction. Okay, that's Article 3, all right? The Constitution certainly contemplates these as three distinct classes of cases. And if they are distinct, the grant of jurisdiction over one of them does not confer jurisdiction over either of the other two. The discrimination made between them is conclusive against their identity. A case in admiralty does not in fact arise under the constitutional laws of the United States. These cases are as old as navigation itself, and the law admiralty and maritime as it existed for ages is applied by our courts to the cases as they arise. It is not then to the 8th section of the Territorial Act that we are to look for the grant of admiralty and maritime jurisdiction in the territorial courts of Florida. Consequently, if that jurisdiction is exclusive, it is not made so by the reference in the Act of Congress to the District Court of Kentucky. The judges of the Superior Courts of Florida hold their offices for 4 years. These courts then are not constitutional courts in which the judicial powers conferred by the Constitution on the general government can be deposited. They're incapable of receiving it. They're legislative courts created in virtue of the general right of sovereignty which exists in the government, or in virtue of that clause which enables Congress to make laws regulating the territories belonging to the United States. The jurisdiction with which they are invested is not a part of that judicial power, which is defined in the 3rd article of the Constitution, but is conferred by Congress in the exercise of its power over the territories of the United States. Now, we know that the territorial jurisdiction of the United States is outlined in Article 1, Section 8, Clause 17. All right, now, my theory is that when they took the money, okay, and then they created this welfare state, I don't think we can argue that we operated in a welfare state, and then the Social Security got created and everybody got Social Security numbers, and now we're all using Federal Reserve notes and things like that, all of which fall within the purview of the legislature, okay? And some kind of way we've been converted from this Republican form of government into this, and this is just theoretical, me causing it. I'm just using this to make a distinction because the word democracy is nowhere in the Constitution. So this democratic type of government where they exercise all this regulatory authority. Now, I don't have a problem with that. I'm not arguing that they're wrong. I'm not arguing that they don't have that authority. What I'm arguing is that they're not properly identifying the exercise of power, where it derives from, and fully being transparent with the American people of the true nature of these actions of these courts. These are administrative agencies. When you get arrested by the DEA, the Drug Enforcement Agency, and they bring you into a district court, that is an administrative action. They do the same thing in the prison system when you get a shot. They come in and take you into a meeting with your counselor. You get representation. It's administrative in nature. They do it all through the federal system. All through the federal system. It's administrative. That's what I'm saying. You don't get, that's what I'm saying. It says your theory is based on a false premise. I will email you the, okay, my theory is based on a false premise. I'd like to know what that false premise is. Because I've been looking at this. I'm gonna look at what this law professor is saying in a few minutes too. Because I don't read, you gotta understand, Juan, I don't study nothing coming out of an echo chamber. I don't listen to none of those idiots. Anybody can listen to them and see they don't study nothing. They're just regurgitating a lot of things that they heard somebody else say. I'm reading all of this stuff. And not to say that I wasn't formally trained in law. Okay, so that's why I will defer to you. Because, I can be wrong. I'm always open to being wrong about things. But I've been reading this stuff for a very long time, studying it intently, not saying I have a definitive answer on anything. However, I do have questions. I just have a little questions on some things. Because the things that they're saying, it just don't make sense to me. It ain't making sense. I said, that don't make sense, what you're saying. All right, so I got a false premise. Okay, so we have separation of powers. We have Article 1, Article 2, and Article 3. Separation of powers dictates one branch of government cannot exercise the power of another branch of government. They form checks and balances on each other. This is an old I think they got this this principle from the French or something like that, if I remember correctly, where separation of powers came from. But this separation of powers, I'm not understanding, even with the delegation of powers, or I see how you can bring an Article 3 judge into an Article 1 court. He can sit in Article 1 court through delegation of powers doctrine. I feel like that would be a good thing to have an Article 3 judge sitting in an administrative court overseeing a proceeding because he's a constitutional authority. However, he's not acting in the capacity of a constitutional authority. There are case law that says that they're operating in with a ministerial duty to perform. And we can go and look at the definition of that and see that that's not judicial. You know, that's the only thing I'm saying. If you're putting people in prison for 30, 40 years because you thinking they selling drugs, a victimless crime or something like that, taking their life away, okay? And I feel like we should have answers to these questions. I feel like there should be answers to these questions because that don't make sense to me. You know, you putting somebody away for that amount of time and I'm coming in, I'm asking you a question, okay, where are you deriving your authority from? Okay, and then I'm bringing up questions like, okay, well, how does this jive with separation of powers? Okay, you have the Judiciary Act. They created a court system, but they weren't vested with judicial authority. So how does an act of Congress, okay, when I look at Article 1, they don't have any judicial power. So how are they making a judicial court? How are U.S. district courts, Article 3 courts, when they haven't been vested with any judicial power? I don't care about the fact of whatever they call it, okay, in light of the fact that, okay, the judicial power is vested with Article 3. There's no argument on that. We know we have delegation of power. This is where I think that they are able to sneak this by through the delegation of powers doctrine. And this is why I'm playing this with Judge Scalia right now. Let's get back to Scalia. We'll get back to American Insurance Company versus Cantor in a second. Let's finish listening to Scalia real quick.
And he was right, and he was right. And his tenure on the court proved to be short. And he was right, and he was right. And his tenure on the court proved to be short-lived in any event.
His tenure on the court proved to be short-lived in any event. I mean, you can hear it that in his voice, he don't like, why he don't like John Jay? That's sarcasm all the way. All right, they talking about, they immediately went in attacking John Jay, Breyer bringing up John Jay, and then this senator, see, this gonna go by everybody else's head. They don't know what's going on right here. 99% of the population will look at this exchange between this justice and this senator and not catch nothing what's going on. But I'm looking at this, okay, why they don't like John Jay? Because I'm reading what John Jay did. He questioned this delegation of powers doctrine in the beginning. Let's look at it.
Now, the situation you pose is quite different, of course, from your leaving it to an agency.
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency because you are increasing the power of the president. You're a competitor to the president. You know, the separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
So the difference you would insist is based on the fact that this is an executive branch agency, which at least in theory is subject to the disposition, subject to the control, to the direction of the chief executive.
I think that's right, and I am what can I, you're talking about the doctrine of unconstitutional delegation of legislative authority, which is a bad name for it because there is no such thing as a constitutional delegation of legislative authority. You cannot delegate legislative authority. Now,
I've been spending time looking at this doctrine of the delegation of unconstitutional authority, and you know, this was going to go into what I'm talking about. Now, he made the example. He said, look, you're giving a different example. The first example with the dog breeding was the delegation of power to a private group, okay? But you can delegate power to an executive because the executive has the power to operate as an executive. You're giving a delegation of power to enforce laws. And just rulemaking authority, because you have to qualify. They cannot delegate lawmaking authority to another branch of government, but they can delegate rulemaking authority, which is what they did also when they delegated power to the Article 3 judges. We can go and read some. They got law reviews out there with some of the attorneys have been writing about this. I'm not the only one questioning. I'm not the only one that's questioning this. I see that. I'm not. Y'all got people in your profession have questions about this as well. So let's continue to listen.
when you give rulemaking to an agency, how far can you go? Can Congress just get together and say, the president can do anything he wants and adjourn? Of course not. That has to be unconstitutional. But is it up to the courts to decide where the line is drawn between giving enough authority to the chief executive and too much authority? It is simply a non-justiciable question, and I, for one, would not let the courts apply the doctrine of unconstitutional delegation, where the delegation is to the executive.
As long as it's to the executive branch agency, then even
I wouldn't get into it. Some of my colleagues would, I suppose.
Even in the extreme situation where we passed a law saying, for example, we shall have good law. The power to make good law is hereby delegated to the Department of Good Law, which is hereby created.
I'd do that one, all right. But that's not going to happen. I'm talking about any real situation. I can't imagine my sticking my toe in that water.
Okay, okay. And Justice Breyer, I had a question for you. I've really enjoyed reading parts of your new book, Making Our Democracy Work. It's very well written and fascinating. I think it's good reading for any law student or lawyer or American who wants to learn more about the system. You suggest in your book, at page 126, that there's rarely an easy answer to the question of what level of government should be primarily responsible for helping to resolve the problems that potentially call for legislation, and that the question usually turns on empirical information such that facts help determine the answers. Yeah. You go on to explain in pages 125 and 126 that very often this means that the courts ought to step aside and, if I'm understanding you correctly, have Congress more or less decide the precise contours of the boundaries of federalism. Is that, am I understanding the book correctly in that regard?
Yes, that's right. I think it's, because you go to abstract, but it's just, if you start talking abstractly, the trouble is you can characterize any individual situation usually in 15 different ways at different levels of abstraction, and depending on how you characterize it, it'll seem appropriate for a federal answer, or it'll seem appropriate for a state answer, a local answer. Is it a police department problem? You say, well, it's arresting somebody. Yeah, but you're arresting them for having guns. And, well, it's a state problem. Well, but the guns are torpedoes and they're only made internationally. And so that's so complicated and difficult that it's hard for the courts to find a general principle there. That's my point there, and that's why.
So if that's the case, and if it's also the case that under, as we read in Federalist number 45, the powers of the federal government are few and defined, whereas those of the states are numerous and indefinite, then members of Congress should read the Constitution, decide what those contours are, and restrain ourselves rather than waiting for the courts to step in and say, no, you've overstepped the bounds.
No, my point that I was making there is you are elected by officials in a state, And so you will make such judgments on such matters as you believe are appropriate in light of how people, partly how they feel and partly what you're trying to represent, but that it is a lot of that is your decision.
Senator, of course you have to make those constitutional decisions. You take the very same oath that I take. The only reason I can look at a federal statute and say, I have to disregard this because it does not comport with the Constitution, the only reason is that I've taken an oath to uphold the Constitution. You take the same oath. So, and we give deference to legislation on the assumption that the members of the Senate and of the House have tried to be faithful to their oath. And if indeed they're not even looking at or even thinking about the constitutionality of it, that presumption should not exist. So yes, of course you.
So in that respect and to that degree, our oath to uphold the Constitution, our commitment not to overstep the bounds of federalism, means more than simply doing that which NLRB versus Jones and Laughlin Steel or Wickard v. Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said. But we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them. Where your law does not comport with the Constitution, it seems to be a law but really isn't, and so we ignore it and apply the rest of the law, the statute notwithstanding, as one of our early cases put it. But it's really, you have the first cut, and the most important cut.
Thank you. Thank you, Mr. Chairman.
Okay. Let me tell you my position. I'm gonna try to clarify my position. Yeah, I know you disagree with the delegation. Here's my position. I'm trying to make it understood. I'm gonna see if I can articulate this cogently. I've never been a person to say that the courts don't have jurisdiction over me. I've never done that. I don't even understand where they get a lot of that stuff from. It's the nature, what we always argued was, well, what kind of court is it? What is actually going on in the courtroom? The people who say that you don't have jurisdiction over me, they don't read any law or anything like that, not even a little bit. But my question is, okay, what is the jurisdiction that's being exercised? Okay, if I'm looking in Article 1, Section 8, where Congress gets delegated their powers, okay, I'm looking, and they can enforce things and, and things like that, but I'm just looking for certain things. They don't have any judicial power. So what that means is this. Okay, let me see clarification. I'm gonna use this analogy. I look at Congress as having a house. If you come into their house, they have all the power. Okay, basically to do whatever they want to do because you came into their house, as long as they do everything and don't go outside, violate the Constitution. But as long as you come within their jurisdiction, which many people do, when they accept benefits and privileges or like to use any type of convenience of modern day society, that's well within the purview of Congress or the legislature. That's something they don't understand. I understand that clearly. They think they can do whatever they want to do. I don't even go with that at all. There's nothing to support that position, what they're talking about. And it's a misunderstanding of the exercise of sovereignty as well. However, what I'm saying is when we are in that, is this a civil action? When they say criminal and civil, because we have penal actions that look criminal, but they're civil in nature. And everybody seems to be involved in making money. I've also had access to a Bloomberg screen where I've witnessed with my own eyes how they apply CUSIP numbers to every case in the United States of America. I've seen that with my own eyes. I even called up to New York and asked them why they're doing that, and they gave me some evasive answer. And once again, I could be wrong, but there seems to be a securitization of these cases going on behind the scenes which is my question. How does that happen? That means there's some sort of creditor-debtor relationship that is being established, which makes sense to me because there isn't any money. How money is created in the United States is through the creation of debt. Okay, so it would, and the United States has a long history of debtors' prisons, long history. The Commerce Court was merged with the U.S. District Courts. They had like a 4-year stint. I'm just taking in all of this, and I'm like, there's a question here, okay? They say admiralty is not admiralty. You know, I've studied that too. I'm not trying to call it an admiralty jurisdiction or anything like that. But, and I'm not saying that they're operating unlawfully. I'm not saying that either. I'm saying that they're not telling us, okay, but criminal proceedings also have a civil aspect to it because admiralty was criminal. There's a criminal aspect to admiralty, but it was civil in nature. Okay, so this distinction that y'all try to draw between criminal and civil, just the existence of penal actions renders that point which y'all making is not true. There are penal actions that are criminal but are civil in nature. Do I need to look that up? Let's look that up real quick. Oh, let me show the people this. All right, let me show the people this. I could be wrong. I could be wrong, but I don't think so. But I could be wrong. Let me see if I can pull this up real quick. My computer running slow, y'all. Forgive me. Now, is this under action? I think it's under action. I forgot. I think it's under action. Let me pull it up. It might be under action. Let me see. Okay, so we go to action. Let me see. Control F. All right, so penal action. And I'm building on some. Okay, there it is right there. I said penal action, a criminal prosecution. 2, sense 2, a civil proceeding in which either the state or a common informer sues to recover a penalty from a defendant who has violated a statute. Although civil in nature, a penal action resembles a criminal proceeding because the result of a successful action is a monetary penalty intended like a fine to punish the defendant. At one time, it was a frequent practice when it was desired to repress some type of conduct thought to be harmful to do so by the machinery of the civil rather than of the criminal law. The means so chosen was called a penal action, as being brought for the recovery of a penalty. And it might be brought according to the wording of the particular statute creating the penal action, either by the Attorney General on behalf of the state or by a common informer on his own account. A common informer was anyone who should first sue the offender for the penalty. Penal actions are still possible in a few cases, and their existence renders invalid several suggested distinctions between civil wrongs and crimes. John Solomon, jurisprudence. Okay. Okay, I understand that, all right? That is your false premise. There are 2 criminal jurisdictions on Article 3. All right, so thank you for confirming that. So am I wrong to come into the courtroom saying, is this civil or criminal? And when the judge tells me it is criminal, okay, I say, thank you, Your Honor. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. The Constitution for the United States of America only grants the judiciary, I guess is what we're talking about, Article 3, right? 2 criminal jurisdictions, one under the common law. You're wrong thinking, wait a minute, okay, so you're saying, hold on, let me make sure I understand. So you're saying I'm wrong? There is no federal common law crimes, only statutory crime. I understand that. I understand that. They'll tell you that on the record. They'll tell you that. Such a penal action is considered the lowest level of crime. Petty offenses punished by fine or jail. I know you're telling me that. However, I have evidence that doesn't support that conclusion. Now we're getting at where I'm at with all of this. I'm not arguing that they don't have jurisdiction. I'm not making that argument. I'm not making an argument that the government is acting ultra virus or de facto or in some kind of way unconstitutional. I'm not making that argument either. What I am saying is that they are in the business of making money behind the scenes. And the nature of this is something that is not being revealed. That's the point I want to focus on. All that other stuff that these people out there talking about is just some bullshit as far as I'm concerned. The money, follow the trail of the money, and then we'll get to the truth. All this, you ain't got jurisdiction over me and all that kind of stuff, just ridiculous, you know. But that's what I'm trying to see. I'm trying to find out what is this is some money involved in this that you're not discussing with me now. When I get on the state level, when I was in Georgia, I found OCGA 1711-1, which states that everyone in Georgia who gets convicted of a crime, there's a lien placed on them that is enforced through the exercise of fieri facias. That's all I'm saying. So that created, if there's a lien, that's a debt, and that's a creditor and debtor situation. And that statute is expressly stating that. Now, I don't care what it applies to, but wouldn't that be a basis for me to come into court and say, Your Honor, I request that the Honorable Judge direct the prosecutor to provide the assessment for the charges along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. I can't ask that if in light of this statute that's right here saying you're about to put a lien on me. I don't have no right to know that information. I'm just kind of curious about that. Hold on, where is this thing at? That's all I'm saying. It's because that is the question I've always had. It's never been this stuff that these people are talking about. And that's why I've always done Secure Party. Even though Secure Party is flawed, got some flaws in it and everything too, but it addresses this point right here that we're trying, this point of contention that we're making right here. That's why I'm looking at this. I'm saying there's some money going on in the back. And you can't tell me it's not, because everything on this planet is about money. And money, we know, is created through the creation of debt. And you can pool that together. You got municipal funds. People were tracking down using CUSIP numbers based off these cases, finding out it's being traded. Okay, there are bonds being created in the background. That's what I'm talking about. And there's plenty of evidence to substantiate that, Juan. There's a lot of evidence. A lot of evidence to substantiate that. Evidence I've seen with my own eyes. Questions I've asked other attorneys who've revealed stuff to me. Now, and me even looking at this, even looking through these law books, trying to see. Now, I could be wrong. Like I said, I wasn't formally trained in law. But I think I'm doing pretty good. However, I have questions. And some of these questions don't get answers, in particular on the record. A Georgia statute doesn't apply. I understand, but the principle, I understand the Georgia statute doesn't apply outside of Georgia. However, would you agree that statute is operating under some sort of principle that can be utilized by other states as well in different forms? Now, this falls under some sort of attachment lien. Now, I already ran through the AI, and the AI say they do the same thing in all 50 states. I may not be able to identify the exact statute. I understand that only applies in Georgia. However, I understand when I'm looking at a state statute, it's usually operating through some sort of universal principle. Would that not be correct? Corpus juris secundum and American jurists are not law. I didn't say that they were. I don't think that they're law. They're legal encyclopedias that can direct me where I can find case law. You know, it definitely will do that. But I'm not saying that that's law. The principle in Georgia. So, in other words, you're saying that Georgia only has certain principles that only apply in Georgia and they don't apply nationwide? Is that how, I have to look that up. So you're saying that there are principles of law that will only apply within certain jurisdictions and not in others? I'm just trying, you might be educating me on some things. I gotta, because that's something I don't know. Then learn from George Gordon and walk into a courtroom. I don't know what he's talking about. Who is George Gordon? Learn from George Gordon. Stay within the U.S., I hear you. They haven't been adopted by other jurisdictions. The principles haven't been adopted by other jurisdictions? Okay, we won't make that argument. Let me just go with Georgia for right now. We'll just stay in Georgia. Okay, so in Georgia, OCGA 1711-1, as well as OCGA 1711-4, that which was very interesting to me about the prosecutor because, this to me, because they bound over almost everything in pretrial, everything, like 100%. And, to me, that's the reason why. But what I'm trying to figure out is, okay, what is this lien? And why is it says may, but we know, because I already pulled up. Aaron, let me pull it up for you. Pull it up for you. I'm going to pull it up. I'm going to pull it up. Let me pull it up for you. And put it on the screen so everybody can see what I'm talking about. Yeah, I know they have the court registry investment system. I know about Chris. Court registry investment system. Yes, I know about it. Oops. Let's see. Hold on. Oh, shit. Come on. What is going on, man? Oh, shoot. Oh, let me see. Is that what I did? I don't know. Thank God. No? Oh, Lord. Let me see if I can find it real quick. I can't. Let me see if I can find it real quick. I think I got it in here somewhere. I was trying to go to my website. I could have found it, but it looked like my website is down. I'm going to have to get off and see what is this right here. I'm looking for, yeah. Let me see if I can find it. Georgia. That's Chisenberger. Where is that, Georgia? Here it is right here. Georgia Criminal Code section right here. All right, so this is the Georgia Criminal Code section. So right here, okay, blow it up a little bit. So it says, imposition of cost of prosecution upon the defendant. Generally, the cost of the prosecution, except the fees of his own witness, shall not be demanded of a defendant until after trial and conviction. If convicted, judgment may, this term right here is deceptive, be entered against the defendant for all the cost, accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien for the date of his arrest on all the property of the defendant. The clerk shall issue an execution on the judgment against the property. Then we go down here. Judge has no discretion in the matter of tax and costs. While the word may ordinarily denotes permission and not command, the use of that word in the second sentence of this section cannot be construed to mean that the trial judge is vested with discretion in the matter of taxing the costs against the convicted defendant. There is no reason, there is no provision of law for the payment of the fees of the offenses of the court when the judges and the judge's discretion fails to tax the costs against the convicted defendant. And it cannot be assumed that it was ever intended that the compensation of these officers should be rest in the discretion of the judge. Okay, so I go down here too, and I got assessment of costs. We got right here, costs are collectible by levy of a FIFA. Costs in the criminal prosecution are collectible of the defendant by the levy of a FIFA at the termination of the prosecution if it finally results in the conviction of the defendant. That's a seizure of property, you know, for the repayment of a debt. Okay, and then we got what I extend the property. What is that? We got cost. What was that? What was that other one down here too? This one right here was interesting too. It says another cost of collectible by levy of a FIFA. Cost of feeding a prisoner while prisoner is in prison awaiting trial, a part of the court cost collectible from defendant. Okay, so I don't know what all the costs are. We know that they're intentionally vague. So if you're putting a lien on me for cost, we have to look that up too, cost, what that is. You're putting a lien on me for cost, not telling me you putting a lien on me. I ain't never seen anybody in Georgia tell any defendant that a lien is being placed against them, not one time, okay? So I just want to know, am I within my right to go into a courtroom in light of what I'm reading right here and ask a judge, Your Honor, I request that the honorable judge direct the prosecutor to provide the assessment for the charges along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. If it is involving me getting convicted of a crime, you sending me to prison and all this. Just kind of curious about that. I could be wrong. Who says entertaining? Is entertaining? What do you say? He said the federal government is mandated to use FASB while state governments are mandated to use GASB. They both use a cruel method of accounting. I'm on that, yes. This is just a way for the court to sink somewhat even further. I don't know about that. Y'all don't get into. See, let me tell you what you need to stay away from in the chat, all right? Y'all need to stay away from all this victim shit. And you know, the court is evil, and that's not gonna get you nowhere. That's not intellectual. That's why you don't see me engaging in it. All right? You just sound like some disgruntled nut job, you know, trying to say something. What you want to do is you ask questions. Okay, you examine it, make sure that your premise is sound. He said my premise is off. It could be. My premise could be off. Because there is a lot of things I'm still murky on, but I can't seem to get the answer. This seems to be the one point when I'm looking at anything else in this book, Analysis, Interpretation of the Constitution, I can read it and understand it, except when it gets to this point about Article 1, Section 8, Clause 9, and Article 3, Section 2 of the Constitution. That get murky. I can't find any definitive answer. It's always written in such a way where they'll say something like, oh, you know, the case of contract. Oh, if a judge is vested with lifetime tenure and salary protection from salary diminution, he's an Article 3 judge. I'm not arguing that. I understand delegation of powers. It's okay, yeah, he's an Article 3 judge, but is he functioning? Is he operating in an Article 3 function? And does he have the capacity to operate outside that, which we have evidence of that, because John Jay, in that letter that he's writing to George Washington, he was saying that. How is a judge going to operate with two hats? The two offices are incompatible. So this is not some wild fantasy. Other people have asked this question as well. Okay, other people have asked this question as well. Juan? People in the professional community. I read it all the time. So this is not some sovereign citizen theory or some sovereign citizen bullshit. I know a lot. There's a lot of that. I'm not even going to question that. Right to travel, that's some sovereign citizen shit. You know, it really is. They don't like it when I say it, but hell, I'm gonna tell them what it is. I'm reading this. You obviously can't read. That's the only conclusion I can come to, is that you can't read. Because it's clear as day when I read it what it says. But on these points, I can't get a definitive answer. It is something that is murky, and you know that I'm telling the truth too. But I always go back to separation of powers. It's impossible for anything Congress is doing to exercise anything coming from the judiciary. And is the adjudication of the enforcement of a statute operating under a judicial capacity conferred by Article 3 of the Constitution. I could be wrong. I could be wrong. I could be wrong. Now, I'm doing this with chat, and even chat is telling me, let's look at what chat is saying. Let's look at what chat GPT, that's what the chat was saying. Okay, I'm going through this right quick. Let's go to the top. All right, that's when I was making my thing. All right. I said, do you remember I uploaded analysis and interpretation of the Constitution by the Supreme Court? Yes, you uploaded referenced analysis and interpretation of the Constitution, the Supreme Court, Library of Congress, Constitutional Commentary, and we used it during our discussion on Article 1 versus Article 3, Judicial Power and Separation of Powers. You also specifically wanted to return to the passage involving John Jay, it was a typo of mine, and the idea of judges wearing two hats. The distinction between exercising Article 3 judicial power and performing duties that may arise from another governmental capacity. If you want, we can pick up exactly there and connect it to the current question. What jurisdiction is the court operating under? What would let us, that would let us separate Article 3 judicial power, Article 1 legislative courts, original jurisdiction, appellate jurisdiction, statutory jurisdiction, and constitutional jurisdiction. Now, my contention is that the Supreme Court, yes, it is subject to the Article 3 powers when anybody is potentially could lose their freedom, because that's the appellate jurisdiction that Article 3 operates under. But that does not convert an Article 1 court into an Article 3 court or Article 3 proceeding. Is my point. Yes, it's subject to some sort of appellate review under Article 3, but it itself is not Article 3, it's Article 1. And I'm talking specifically about the U.S. District Court of the United States. I've seen a lot of stuff. I've seen a lot of stuff. This has only been my only question. And I think this is the thing that y'all can't talk about. I just think it's something y'all, I just think it's something y'all can't talk about. You're not allowed to talk about it. Because when you press too hard in that area, that's when things start, getting weird. Let's keep going. I asked what page was John Jay at the discussion he had with George Washington on. Yes, I found the exact passage in the copy you uploaded, the passage we were discussing about Chief Justice John Jay, George Washington, and the concern about judges effectively wearing two hats is on printed page 599 of Analysis and Interpretation of the Constitution. In the PDF file itself, it appears, I don't think he got the page numbers right. He said, but it is a lot of stuff there. We'll look at it in a minute. The key footnote says that Washington sent a letter asking for suggestions regarding the judicial system. Jay prepared a response raising constitutional objections, including that the same man, this is a quote, the same man should not be appointed to two offices, that the offices were incompatible. Now you see why Justice Breyer, when they brought up, interrupted John Jay, answer this question. You gotta pay attention. See, it's a lot of stuff going on, man. But when you see stuff like that, it's a lot of stuff, undercurrents that y'all not paying attention to, that you wouldn't know to pay attention to. But it goes, that is the passage we were using in our Article 3 separation of powers discussion. There's also a second Washington Jay discussion, so don't confuse the two. Printed on page 599, Washington asked for suggestions concerning the judicial system. Jay raised the problem of the same person holding two incompatible offices. This is the one connected to our two hats discussion. Printed on page 762, the famous 793 advisory opinion episode where Washington and Jefferson asked the Supreme Court to answer legal questions concerning neutrality, and Jay and the justices refused based on separation of powers and the judicial role. So the page you were looking for is on page 599, and this is the particular, okay. I said, and then so I uploaded this Penn State review that we're going to look at. I uploaded it. So the U.S. District Courts are article, so are the Circuit Courts of Appeals. That's what I'm, okay, I'm going to give you that. They are Article 3 courts. When they're enforcing a statute, are they operating as an Article 3 court? If they're enforcing a statute. Are they operating in an Article 3 capacity? Yes, in several important respects, Professor Akhil Reed Amar is very close to the constitutional framework you have been developing, especially on Article 3, separation of powers, jurisdiction, and the importance of asking what power a court is actually exercising. But there are also some important places where this position is narrower or different from yours. The article in Amar's The Two-Third Tiered Structure of the Judiciary Act of 1789, published in the University of Pennsylvania Law Review. And this is this thing I'm reading right here. This right here, this Article 3 in the Judiciary Act of 1789, the two-tiered structure of the Judiciary Act. All right? So you're saying that when they're enforcing a statute, that they're operating judicially, not ministerially? I like that. When a court of general jurisdiction exercises jurisdiction under a statute, it becomes an inferior court due to separation of powers. My position exactly. But he's saying that it's not. He's saying it's not. This is the point of contention, Juan. This is the point of contention. So if we do a live, that's going to be the point of contention. Right there. That's my point of contention. And I think that I can bring a strong argument against your argument. You send me your case law. Let me review it. I'm gonna send you what I got. I'll send you what I got, and we'll see. And I'm gonna. We can use the cases. We can use the cases because I like to read the cases because I like to see how the judges hide stuff by couching it in legalese in such a way, because they can just because it's in those it's been cited doesn't mean, if you have to read what these judges are saying. And that's what I want. That's what I want to look at. I want to look at that. It says, let's get back. It said the two-tiered structure of the Judiciary Act of 1789. Now I found this from the analysis and interpretation of the Constitution by the Supreme Court that led me to this. This is a professor at Yale Law School. This essay and its companion, Infra, page 651, grew out of my participation in the Bicentennial Conference of the Judiciary Act of 1789, jointly sponsored by the Georgetown University, the Bicentennial Committee of the Judicial Conference of the United States, and the Supreme Court Historical Society. In addition to these sponsors, this is the sponsors thing. I ain't reading the sponsors. Where is it at? They're talking about jurisdiction restriction. I ain't gonna read this right now, but I did run it through chat. I want to read it, but it's just too long. I got time. I want to read it, but I can't get into it like I want to, because I do that. I'll get into reading it because I like reading this kind of stuff. I like this stuff. Is a yes, and it says the article in Amar's The Two-Tiered Structure of the Judiciary Act of 1789, published in the University of Pennsylvania Law Review. The strongest point of agreement, Article 3 power has to be taken seriously. Amar expressly rejects the idea that the Article 3 can be read piecemeal. He insists that we look at the judicial power of the United States as a whole and analyze the Supreme Court, inferior federal courts, original jurisdiction, appellate jurisdiction, tenure, and salary protections together. My contention exactly. That is very close to the argument, and like what Chad is going to tell you, that is very close to the argument you have been making. You cannot determine what kind of authority a federal judge is exercising merely because someone calls the tribunal a court or calls it an Article 3 court. You can call it that all you want to. You can call it whatever, just like I call a tennis court, a basketball court. Using the word court or saying it's an Article 3 court is just a label. But actually, what is the function? And what capacity is that Article 3 judge operating in? That's what I want to know. And once again, I'm thinking separation of powers. And this is where I can't get any clarity because y'all don't make that sense. What you're saying doesn't make sense to me in light of separation of powers. It says, that is very close to the argument you have been making. You cannot determine what kind of authority a federal judge is exercising merely because somebody calls it the tribunal or court. You have to identify the constitutional source of power, the office being exercised, and the jurisdiction being invoked. Amar goes further and says Article 3's mandatory language matters. He attacks what he calls selective literalism, which is what I think a lot of people in the legal community do, because it emphasizes Congress's power over inferior courts and appellate exceptions while minimizing the Constitution's commands that judicial power shall be vested and shall extend to all cases in certain categories. That is very much in the direction you have been arguing. He absolutely distinguishes constitutional judicial power from congressional power. This may be the single most important paragraph for your presentation. Amar summarizes his own position this way. Article 3 vests the judicial power of the United States in the federal judiciary and not in state courts or in Congress. He says that, and then says Congress may create inferior Article 3 courts, but Congress does not possess the judicial power itself. My contention exactly, in light of separation. You can't give a power you don't possess. That was the argument John Jay and all them, the original justices, were making about the sovereignty of the American people, because we could not delegate power to government officials that we did not possess. So if the government is operating in some sort of sovereignty, that means the people have to be sovereign. But y'all have demonized that word. I understand why. You've demonized it. You did a very good job of demonizing the word sovereignty, because I can go back and read old case law and see that the American people are called sovereigns, not sovereign citizens. Now, are they confused on the exercise of that sovereignty? Yes, 100%. I'm not sitting here arguing they can do whatever they want. He said, I've challenged and litigated many statutes in Article 3 courts per Section 2 of Article 3. Not debating that. You may have, okay? How many cases have you litigated in federal? Oh, Smart Lock TV. Yeah, you don't want, hey, my man, hey, listen, y'all. Juan has argued in front of the Supreme Court. Okay, that means he knows something. Okay, I'm not saying I defer everything to them, but the first thing let me teach y'all about staying in honor. You got to respect everybody in the public offices as well. You can't be disrespectful. And a lot of you're angry about something that has happened to you, and I understand why. Look, I went through it too. And if it wasn't for that attorney in the beginning telling me, he told me, he said, look, we can deal with the ones like you. It's the angry ones we can't deal with. And I understand what he means, because at that point, I wasn't really familiar with this space. But now that I've become very familiar with it, people are very emotional in this space. They're not very intellectual. They're more emotional than intellectual. And then they derive conclusions through emotion other than independent study and research, good research. And you're wrong most of the time. And you don't like coming over here listening to me because I don't want to get in, wave some pom-poms to what you're doing, because what you're doing is ridiculous to me. And you don't like me saying that because you have a tradition of following all of this nonsense. This is a tradition that you are following. It's not substantiated in anything. It's just a fucking tradition. And when I look it back, it's very few people who've actually engaged in actual study into these particular subjects. It's only a handful. The overwhelming majority are weekend warriors that go and read it for about 2 weeks, think they know the law, and then go in and try to defend themselves. And then when it don't go their way, they start calling the judge corrupt. That has to stop. And it's going to stop. Y'all have AI here now. I see that it's being used more and more, Y'all, but I say in about another year, all this bullshit that y'all talking about, it's going to be dead. Because people are going to have too much access to verification sources. It says, I have worked on cases that have set precedent as U.S. Supreme Court and won, benefiting everyone in the U.S., even you. Yes, he has. Yes, he has. Yes, he has. He's not lying about that. Show the man some respect. Show the man some respect. Please do not disrespect my guest. All right, let me finish this right here. He then says, Congress may create inferior Article 3 courts, but Congress, okay, they strongly support your separation of power emphasis. Article 1 legislative power does not equal Article 3 judicial power. Congress may constitute tribunals, define statute. Okay, so right now, let me show y'all this. I drew this up 15 years ago, about 15 years ago. But I want y'all to see how close I was to getting it. This was 15 years ago when I first started this. Now, the Supreme Court has stated that there are three different meanings to the word United States. United States used in the sense of when they're operating in their territorial capacity. United States in the sense when they're operating internationally, when they're dealing with other countries. And then the United States, when we're talking about all 50 states coming together collectively, united together. Okay, so now I'll pull the site if anybody wants me to, but that is actual truth. So now a lot of people have kind of tried to interpret what a lot of people made a mistake is by trying to say that the United States is a corporation. Y'all got to stop that too. You got to stop that. You got to stop that. You got to stop that too, all right? It's not, it's not what it means. It's not what it's saying. However, there are different capacities that the United States can act in. And when they're acting in the capacity of a territorial governance over a territory, and we have to define it. Another place that that's been very murky with me is getting a good understanding of the word territory. Okay? Trying to get something real deep on that, how the exercise of that territory. But a territorial jurisdiction, they operate within. Now, under that, they can delegate their delegation of powers doctrine when they delegate power to these other branches of government. That's what this line right here represents. It represents a delegation of power to the executive, okay, as well as the judiciary. They do that, as well as, they got this legislative function, their administrative, democracy in their capacity. But up here is how they operate originally as intended under the Constitution. Okay, Article 1, Article 2, Article 3. However, when we get to this Judiciary Act and all of this kind of stuff and the Federal Reserve Act, okay, all that's promulgated by Congress. Social Security numbers, benefits and privileges, all that's coming from Congress. A regulation of commerce, all that's coming from Congress. So they create these tribunals, okay? I can see them doing that to adjudicate matters that are within their cognizance or within their purview, okay? And whatever the resultant decision, if you feel like it was unfair or unconstitutional, we can appeal to a constitutional court after we have exhausted all of our administrative remedies, as they are always telling us. Okay, you have to exhaust your administrative remedies. What does that mean? Why is the Supreme Court justice saying that? You have to exhaust all your administrative remedies before you come talk to us. And then we have the Ashlander rule, rule number 6, the Ashlander rules, Okay, I'm just looking at all of this. And every time I look at this, I see that, and the political question doctrine, okay, the political question doctrine, is it a justiciable issue? Why is it not a justiciable issue? Because it falls under the purview of one of the other two branches of government. The political branches are the legislative and executive branches of government. So if something falls within their purview, the Supreme Court, because of separation of powers, they have to respect that, and they can't trample into their territory. So you have to exhaust all available remedies that they provide for you, and they are the court of last resort. If you can't do it, then we'll take a look at it. That's all I'm saying. I'm looking at this, and everywhere I look, it just doesn't make sense what you're saying to me. Now, if somebody can make it make sense, okay, I'll roll with it, but okay, like right here. Let's look at this right here. I pulled all this out of Black's Law Dictionary. Now, I don't like to just pull definition of words. I like to read the cases, but time is short. All right, so over here. Article 1 court, see legislative court, a type of federal legislative court that is not bound by the requirements of or the protected under the U.S. Constitution, Article 3, Section 2, and that performs functions similar to those of an administrative agency, such as issuing advisory opinions. Congress also has power within certain limits to create what are called Article 1 tribunals. These Article 1 tribunals are really akin to administrative agencies. That is, the judges do not have constitutionally guaranteed lifetime tenure and protection from salary diminution. Is that the only way that we will know that they're Article 1 judges? Because that's deceptive, because you could have a protection from salary diminution and a lifetime and have a lifetime office, but not be operating in an Article 3 capacity as a result of something that has been delegated to you. But that doesn't address this point right here. So that's how that can be deceptive in what it's saying. So it goes on, it says, they're not governed by the case or controversy limitation of Article 3 at the present time. Article 1 courts include territorial courts, certain courts in the District of Columbia, courts martial, and legislative courts and administrative agencies that adjudicate public rights. Now notice that part, they said legislative courts and administrative agencies. They didn't want to say U.S. district courts. Because the public rights doctrine is always at the central issue of any one of these agencies, whether it's the DEA, Drug Enforcement Administration, ATF, whatever agency. Let's look at this right here. It says, I could be wrong. I'm not saying I'm right. I'm not in any way saying I'm right. Okay, we know this Thompson versus Smith. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely ministerially. And when we look up the word ministerial act, that means they're not exercising any type of skill or anything like that. They're essentially doing what they're told. They're doing what they're told. Okay, I'm not arguing that, Juan, not arguing that. You're absolutely correct. However, we're talking about in what capacity is the Article 3 judge acting in when they are enforcing a statute. And my argument is it's not in a judicial capacity, it's in a ministerial capacity, okay? They're acting ministerially, not judicially. Now, that's the case. And that jives with separation of powers. That makes sense. That makes sense to me. That makes sense to me that you could delegate some authority to an Article 3 judge, have him come and sit in your Article 1 court, and in which now you are, even though you still have the title Article 3 judge, the capacity that you're acting in is not Article 3. It's Article 1. That's what I'm saying. And I think that's how a lot of people get deceived. That's what the deception is, right? That's the line of deception of where it begins right there. By saying, oh yeah, he's an Article 3 judge. Yes, he is. That's a true statement. That's a very true statement. But is he functioning in the capacity of an Article 3 judge when enforcing a statute? Not when he's acting in an appellate capacity, because we know Article 3 did allocate that power to, the Constitution allocated that power to Article 3. I get it. I get it how they could be subject to Article 3, but I'm talking about that first, when I come in that lower level court, a U.S. District Court, when I come in there, what kind of court am I coming into? I think everybody in America wants to know. Because I've went in there and I've asked them, and they don't tell me what they're telling you. Because when I go on the record, Okay, when you're on the record, they're going to be very careful of what they say. And that's my only question. I got a question about that, Juan. That's it. That's it. I think, do you think my position is at least very intelligently presented? You know, it's not ignorant. You know, I'm sure, you know, it's researched. It's a valid question. Yes, it might be, a premise might be off. I will concede that. However, I mean, could you see why somebody would, if I am just a layman in this particular field, could you see how a lot of people could be reading all of this stuff and then be mistaken, and then instead of putting out a lot of videos about them, call them weirdos and things like that, why don't you put out a statement clarifying the issue definitively in a way that everybody can understand? That would be very difficult to do if you had something to hide, like you making money behind the scenes. I would just like to keep it with the status quo. I'm just saying. I'm just saying. Now, let me say this. Now, everybody, they're going to start with this in the scope in which an administrative agencies can act. My argument, everyone, is not, I'm not saying they're acting outside the ambit of their delegated authority. I'm saying that they are exercising the authority that has been granted to them, but they're making it look like it's a judicial proceeding, that it's truly operating under the judiciary, but it's not. That's my only thing. I'm not arguing that they are not that they're doing something wrong as far as the powers that have been conferred to them. That is not my argument at all. That's not my argument. I'm not making that argument. You're clear in your presentation just based on a false premise. All right, we can argue the premise. That's going to be our point of contention, my premise then. All right. Okay, I'll get with that. I'll get with that. All right. I can see I'll be open, and I'm going to be open to concede if I'm wrong in something. But I've been studying this and looking at this, and there's a lot of, and I read law reviews. I read cases, and I just haven't been able to find a definitive answer right here. It said, now I agree that you might be nice with the Constitution because you argued in front of the Supreme Court. I will concede that you're nice with the Constitution. You probably have been doing this for a very long time in light of the fact that some of your friends are, and who your friends are. I respect that. I respect that immensely. So we're gonna get to, but I still have a question. I still got some questions. Just because I respect it don't mean I'm just gonna lay down. I'm not gonna lay down. All right. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. That sounds like a ministerial duty. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence to, okay? And this week I was looking up territory, the law that applies to all persons within a given territory regardless of their citizenship or nationality. I hope everybody out there saw that. Okay, if regardless of your nationality or citizenship, if you operate, but I didn't know, well, what's the territory? I didn't get too much clarity on that. Could be wrong. I mean, I could be wrong. I'm sure some people can explain it to me. Domestic terrorism, I kind of looked up this terrorism that occurs primarily within the territorial jurisdiction of the United States. Terrorism is carried out against one's own government or fellow citizen, federal citizen, or citizen of the United States. Okay, now, we know that this right here, Susan B. Anthony versus the United States. Let me look at something real quick, too. All right, let me throw this in the pot. Let me throw this in the pot. That's not the one I'm looking for. Where is the case at? Oh, this is it right here. I think this is it. Bam. Yeah, that's it right there. All right, so right down here. Okay, so what is this? This is Susan B. Anthony. You may have the Susan B. Anthony dollar. Probably one of the first feminists You know, feminism probably started taking foothold back then. But anyway, constitutional law, 14th Amendment, right to vote, women's qualification of voters. There it is right there in case y'all, interested in pulling it up yourself. So I go down here, right? I'm looking at this. Okay, it says the 13th and 14th and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes, but full effect must nevertheless be given to the language employed. The 13th Amendment provides that neither slavery nor involuntary servitude, except as a punishment for a crime where the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. If honestly received and fairly applied, this provision would have been enough to guard the rights of the colored race. In some states, it was attempted to be evaded by enactments cruel and oppressive in their nature, as that colored persons were forbidden to appear in the towns except in a menial capacity, that they should reside on and cultivate the soil without being allowed to own it, that they were not permitted to give testimony in cases where a white man was a party, that they were excluded from performing particular kinds of business, profitable and reputable, and that they were denied the right of suffrage. To meet the difficulties arising from this state of things, the 14th and 15th Amendments were enacted. The 14th Amendment creates and defines citizenship of the United States. It has long been contended and has been held by many learned authorities that have never been judicially decided to the contrary, that there was no such thing as a citizen of the United States, except as that condition arose from citizenship of some state. No mode existed, it was said, of obtaining a citizenship of the United States except by first becoming a citizen of some state. This is why they have this state argument, state citizen argument. However, it's bullshit too. Yes, I know it is. I'm not arguing for it by reading this. They don't understand how they have to adjust their conduct or what actually applies and what doesn't. But I'm not arguing for the state citizen argument. However, it was interesting to note that there is truth that, hey, you had to be a state citizen to have citizenship within the United States before the passage of the 14th Amendment. So the 14th Amendment defines and declares who shall be citizens of the United States. To wit, all persons. It uses the word person. It does not use the word black or white or anything like that, y'all. Use the word person. And y'all are having a problem. Y'all are struggling with that term. There are natural persons and artificial persons that determine, and then they determine capacity, and that gets a classification in order to determine rights, duties, remedies, and liabilities. It's part of some formula that they use. Y'all making it into the magic invisible man. The latter qualification was intended to exclude the children of foreign representatives and the like. With this qualification, every person born in the United States or naturalized is declared to be a citizen of the United States and of the state wherein he resides. Okay. All right, well, y'all can read that if you want to, but I thought that was interesting too, that prior to the 14th Amendment, there was no such thing as a U.S. citizen. Now, a U.S. citizen is a federal citizenship. There's case law that clearly lays that all out. It's called a federal citizenship. And you can be, prior to the 14th Amendment, you could be a citizen of a state without having a federal citizenship. So I'd like to know when that ceased to be. And how did it cease to be? What triggered that, or what was it that allowed for that to happen? Who made that decision that no longer can you just be a state citizen as opposed to a federal citizen, that now we have to both be the two? Where did that, I see you got the Constitution right here, but I'm like, we have to define, well, what do it mean when they say United States? In what sense were they using that word? Because the Constitution only applies to the federal government. So in what sense is the word United States being used right there too? It only makes sense when you read it, when you take the principles into consideration, like separation of powers, then things begin to make sense. It only becomes confusing when those principles are ignored. Now you know the real reason for the Civil War. I'll start talking about some crazy things. But anyway, let me get back to my chat. It says, Your two hats observation gets remarkable support. This is where the article becomes especially relevant to what we were discussing about John Jay, Washington, circuit riding, and judges acting in different capacities. Amar explains that the Supreme Court justices riding circuit could not simply be understood as exercising the Supreme Court's jurisdiction while sitting in a lower court. Why? Because that would arguably expand the Supreme Court's original jurisdiction, something Marbury said Congress could not do. That makes sense to me, Juan. That makes sense to me, what's said right there. If a Supreme Court justice or any Article III judge in that sense is he's acting in a different capacity, how can it still be, it's expanding their function, which is something that's not authorized under the Constitution. So they have to be acting in a different capacity. It says, his solution is striking. Supreme Court justices were themselves simultaneously lower federal court judges. He says, understanding them in that capacity avoided treating circuit cases as exercises of the Supreme Court's original jurisdiction. That's my contention exactly. That's why the chat said it's aligning with me. Okay, in that sense, if they're acting in some ministerial capacity, okay, then everything they're doing is cool. But you can't tell me that an Article III judge is being placed in an Article I court or an administrative court or a legislative court and is still exercising in the capacity of an Article III judge while enforcing a statute. That doesn't make sense to me. That violates separation of powers. That doesn't make sense to me. Now, my premise could be off. Somewhere in there, if I am wrong, it's in that area. It's in that area. Help me find it. I'm open to that. State court, federal, two different constitutions. They only accept, I read that. If everyone knew legal history, this shit wouldn't happen. I don't know about legal history. If you have to know legal history, I think that you have to really understand basic civics. I think what has happened, and most of the confusion to me, where I see that it lies in the fact that the majority of people don't have a basic civic education. Something that's even close to something that you learn on Schoolhouse Rock. And I mean that seriously. That's how far that the majority of people have failed with their understanding of civics. So before you can start pointing the finger at the government, I would make sure that I at least had some sort of remedial education in civics. So, I'm not saying I'm the best in it, but it's just like some of the things that y'all say is just ridiculous. It's ridiculous. You can't support it if you're an intelligent person and you've done even a cursory examination into the law. You're not going to be able to jive with what y'all are saying. That's how I know y'all ain't even opening the books and reading nothing. You're reading echo chamber theories and doctrine. You are not in these law books reading it because you're being told that they are corrupt. You're being told they're corrupt. But you're being told they're corrupt by fools. Who want to hide their ignorance by preventing you from going and actually reading this for yourself. Some of you, I'm just going to be honest, you probably don't have the ability, this may be a little too transcendent for ordinary capacities. Let me say it like that. But I believe that anybody can learn it, with devoting enough time to the study of it. Do I think that they should, yes, civics should be reestablished. Man, you should be learning it all the way from elementary school. How are they expecting you to function in a civilized society and you're not being prepared to enter it ever since from the time you're a child? Equitable principles, all that stuff should be taught in elementary school. You should be getting acquainted with all that as far as back as elementary school, in my opinion. Ignorance of the law is no excuse. Well, how are you supposed to know the law? You got to read it. Who has time to read it? These people out here trying to go to work. They trying to survive. Who's going to have time to read this? I just got some questions, that's all. That's why they need people like us in this space. People have time to actually go and read this stuff and analyze it and make a report back. But it goes on, it goes on, let me read this. It says, Amar explains that Supreme Court Justice's riding circuit could not simply be understood as exercising the Supreme Court's jurisdiction while sitting in a lower court. Why? Because that would arguably expand the Supreme Court's original jurisdiction, something Marbury said Congress could not do. His solution is striking. Supreme Court justices were themselves simultaneously lower federal court judges. He says understanding them in that capacity avoided treating circuit cases as exercises of the Supreme Court's original jurisdiction. That is remarkably close to your "what hat is the judge wearing" inquiry. But there is a crucial qualification. Amar is talking about two Article III federal judicial capacities, not an Article III judge magically turning into an Article I tribunal. And Amar acknowledges that even this arrangement raised serious constitutional questions involving multiple office holdings and the appointment clause. So your instinct that capacity matters is supported, but the article does not establish the broader proposition that a judge can freely switch between Article I and Article III authority without constitutional consequences. They can under the delegation of powers doctrine. They can under the delegation of powers doctrine. It can be delegated to him to act in an ministerial capacity. That makes sense to me. That makes sense. Omar makes an important distinction you've been emphasizing about the Supreme Court's jurisdiction. He says something unusually precise. The Supreme Court is the only court that, strictly speaking, derives its jurisdiction directly from the Constitution itself. My point exactly. Okay, so Congress, these courts, they are deriving their authority by the Judiciary Act. Okay, well, Congress can't confer a power that wasn't conferred to them, and they weren't conferred judicial power. So how is any judicial power conferred in the Judiciary Act? I just got questions. I just got questions. That's all. I just got questions. It's just a question. Without violating separation of powers. I could be wrong, and I'm not saying that I'm right. Maybe I'm kind of confused on separation of powers. Maybe I'm confused on the original appellate jurisdiction of the Supreme Court. Maybe I am confused on what a ministerial exercise of power is. Maybe I'm confused on Article 3, Section 2 of the Constitution. Maybe when it says in all other courts that Congress may constitute or create, maybe I'm confused on the meaning of that. But I'm just trying to say, I look at it through the lens of separation of powers. That's the lens. I don't care what language is in the Constitution. There is a principle of separation of powers, and each of those branches of government are at war with each other. That's why you have checks and balances. So that lets me know that one can't possibly be exercising the power of the other. That makes sense to me. The other explanations don't. Congress does not confer jurisdiction in the Supreme Court. It goes on, Congress does not confer Supreme Court jurisdiction in precisely the same way that it confers jurisdiction on inferior federal courts. The fuller passage is even stronger. Amar says, Congress does not confer jurisdiction in the Supreme Court in the same way it confers jurisdiction on the lower court, federal courts. He criticizes the Judiciary Act of 1789 for sometimes speaking as though Congress were granting the Supreme Court jurisdiction that constitutionally already existed. That is my contention exactly. That's the same thing I'm saying. They acting like the Congress created the Supreme Court. That's how they talk. It's impossible. It's impossible. This is where the lies start. See, this is where everybody needs to start their investigation, because this is where the truth has been hidden. This is where the truth has been hidden. He criticizes the Judiciary Act of 1789 for sometimes speaking as though Congress were granting the Supreme Court jurisdiction that constitutionally already existed. That supports an important distinction for your presentation. Supreme Court constitutional jurisdiction versus congressionally created statutory jurisdiction of inferior federal courts. Those are not identical propositions. Original jurisdiction is particularly important. Amar is quite emphatic that Congress cannot simply rewrite the Supreme Court's constitutionally fixed original jurisdiction. Listen, I haven't been formally trained in law, but at all the years of me reading this and studying principles and things like that, you can't help but arrive at the same conclusion. If you recognize, that's why I say a lot of people out there don't understand the principles that underlie the Constitution. They don't, and how important they are to know. And one of them is separation of powers for you to understand. I always tell you, you're not going to understand the courts if you don't understand separation of powers and delegation of powers doctrine. You're not going to understand it. So you got to understand these two things, that they can delegate authority to another branch of government. But can they operate in the same capacity under that delegation is the question. I could understand why Congress would do that, to give the appearance, to give certain appearances, delegate some power over to an Article III judge, come sit in our Article I court, to give the appearance that we're operating as a true judiciary and not some administrative agency. I think there is a deception right here, and I could be wrong, but I don't think I am. Original jurisdiction is particularly important. Amar is quite emphatic that Congress cannot simply rewrite the Supreme Court's constitutionally fixed original jurisdiction. He describes a broad consensus that the court's original jurisdiction over ambassador cases derives directly from the Constitution and is outside ordinary congressional jurisdiction stripping authority. Now, notice that Congress has jurisdiction stripping authority. What authority can Congress strip from the Supreme Court? There is something they can. They can prevent. That's what that Jarsky case was all about. Under the Dodd-Frank Act, can Congress create a jurisdiction in which the Supreme Court can exercise any type of appellate authority over? Yes, they can. Yes, they can. Original jurisdiction is not simply whatever Congress says it is. Article 3 itself assigns original jurisdiction to the Supreme Court in specified categories. However, and this is a significant difference you should know, Amar has an unusual two-tier interpretation. He believes Congress may restrict the Supreme Court's original jurisdiction involving state party cases. Even though he believes ambassador cases constitute an irreducible constitutional core, he acknowledges that position himself. So Amar does not take the simplistic position every word of the Supreme Court's original jurisdiction clause is completely immune from congressional regulation. Well, nobody said that. Notice they use the word congressional regulation. Okay, I'm not saying it can't be regulated. It can be regulated, yeah. Okay, however, is the nature of it truly judicial? His theory depends upon the Article 3 distinction between all cases and certain controversies. His two-tier theory is fascinating for your jurisdiction argument. This is Amar's central thesis. Article 3 says judicial power extends to first tier, all cases arising under the Constitution, laws and treaties, affecting ambassadors, ministers, and consuls, admiralty, and maritime cases. Then Article 3 shifts language with describing the other jurisdictional categories. The Constitution doesn't repeatedly say all controversies. Justice Story noticed this in Martin versus Hunter Lisi, and Amar builds his entire theory around it. Did I pronounce it right? Lisi. Story's interpretation was that the first class had to be embraced by the federal judicial power in either original or appellate form, while Congress had considerably greater discretion over the second category, which is the appellate form. Same thing I'm saying. You listen, it's not that I'm some super genius or anything like that. It's just that when you know certain principles, and I'm not saying I've mastered the principles and everything, but if you got a basic understanding of the principles, that's going to guide your reasoning when you read all of this. And you'll also understand why the judges say certain things. because they usually don't say things expressly. Like they won't expressly say this violates the separation of powers. Sometimes they will, but sometimes they'll phrase it in a different way. But when you understand what the principle is, you can identify it no matter how they express it. And that's why you start with principles. I was reading this old historical book, and it was talking about, I can't remember if it was Judge Iredale or John Jay, or I can't remember which original Supreme Court justice it was, but I do remember he was giving a speech at I think it was in the University of Pennsylvania, to law school students there. And one of the students said, how are we going to learn all this? This is a lot of stuff to read. It was something like that. May not be paraphrasing it correctly, but it was something that he was overwhelmed by the full body of law. And he told him, he said, you're not supposed to be studying that. You're supposed to be studying the principles. Master the principles. And that's exactly right. When you understand the principles, like the principles of equity, it makes reading a trust document or even a decision of a judge in an equity court, it's very nice to read because you can follow the judge's reasoning and then you can judge him based off of that. And you can say, man, that judge, the way he applied those principles, that was nice, how he applied those principles. And it's like you'll look at him in a totally different light. You won't be running around talking about the judges are corrupt or anything like that. No, you will be able to appreciate his intelligence. And you'll begin to understand, hey, I understand why this dude is a Supreme Court justice. Yeah. It says the Jerksey case was about the right to a jury trial before Jerksey could be fined $300,000. The rest is dicta. Okay, dicta, I understand that. It's just like dicta is not, it's not an authority you have to follow. It's just basically, they can take it under advisement if they choose to. But I understand that's what the Jerksey case was about. However, in the Jerksey case, it was a question about whether or not, because I just read that the amicus brief yesterday, when they were talking about it, and it was talking about they gave them the discretion to have either a jury trial or a bench trial, and they never elect to have a jury trial, and how they have this 100% success rate, and whether or not they were, violating somebody's constitutional right. And, I would actually say that I think that I haven't read the holding in that case yet. I haven't finished reading it, but I would say that they do have the right to kind of do that. In a way, I think with the taking of somebody's freedom, though, I don't think they ever have a right to do that. But I think that they have do have some discretion to engage in what they call in here jurisdiction stripping. I can see it. If you want me to be honest, without regarding any imperfections, defects, or want of form in such writ. What is that? From time to time, amend all and every such. I don't know. He's posted a whole bunch of stuff. Okay, P ain't got time to read all that. His two-tier theory is fascinating for your jurisdictional argument. This is a mere central thesis. Article 3 says judicial power extends to blah, blah, blah. Read all that. Okay. Story's interpretation. Let me get down there. Justice Story noticed this in Martin versus Hunter Lisi, and Amar builds his entire theory around it. Story's interpretation was that the first class had to be embraced by the federal judicial power in either original or appellate form. That's right. The Supreme Court, that is why they embrace it, either in their original or appellate form. When it's something that is dealing expressly with something that has been delegated to Congress, they only embrace it in appellate form. While Congress had considerably greater discretion over the second category. This is a major point for your current presentation because it shows that original versus appellate jurisdiction is not just procedural vocabulary. It is part of a constitutional architecture by which the Article 3 judicial power is distributed. Oh, man. You can't argue with that. The brief did its job, and it was ruled that a jury trial was part of Jaworski's due process. Okay. That amicus brief was nice. I read it yesterday. On the live. It was nice. It was nice. I had a feeling he would win. He had a strong argument. It was nice. It was very nice. He said, but here's where Amar would disagree with one possible version of your argument. This is important. In your proposition, a case involving a federal statute is an Article 1 matter because Congress created the statute, so an Article 3 court cannot adjudicate it. That's not what I said. And I'm going to correct him down here on the bottom. That's not what I'm saying. I'm not saying that an Article 3 court cannot adjudicate it. I'm saying that when they adjudicate it, it's not in the capacity of Article 3. It's in the capacity of some sort of ministerial function that has been delegated to them through some sort of statute. He couldn't have his money taken without due process. Yeah, how did I find that Jarsky case? I found that Jarsky case because I was doing this. You know, I was researching all of this, and it came across my desk, and I felt like I needed to look at it. It was good. That was a real good brief. He made some strong arguments in there about. It was some nice arguments he was making about. I think it was the SEC, how they're acting as if they didn't have to, didn't have to provide due process. And I just like the way he articulated it. It was nice. It was nice. His arguments were strong. So I'm not surprised he didn't, I'm not surprised that he won. Whenever Congress can legislate, the executive must have coordinate authority to execute and the judiciary to adjudicate. Federal laws are enacted legislatively, executed by the executive and adjudicated by the federal judiciary. This resolves the question you asked me recently. In light of separation of powers, how can statutes be adjudicated in Article 3 courts? Okay, we're down here. I asked him this question. Wait a minute, where did I ask that question? I said, based on the information, the Judiciary Act could only create Article 1 courts with the Supreme Court exercising appellate jurisdiction, which is the case with the U.S. District Courts. Not quite. The law review you uploaded actually cuts against that conclusion. Amar's position is that Congress may create inferior Article 3 courts. He expressly summarizes his view this way. Article 3 vests the judicial power in the federal judiciary. The Constitution requires one Supreme Court, and other Article 3 courts may, but need not be created by Congress. Okay? The key distinction is who creates the court does not equal what constitutional power the court exercises. Congress creates the lower federal courts by statute, but Article 3 itself anticipates that arrangement when it speaks of such inferior courts as the Congress may from time to time ordain and establish. So Congress's acts of creating the institution does not automatically make the resulting tribunal an Article 1 court. Amar is particularly clear about this. He treats Supreme Court judges and inferior federal judges alike as Article 3 judges, and I have acknowledged that, emphasizing that they share the constitutional characteristics of presidential appointment, Senate confirmation, tenure during good behavior, and protection against diminution of salary. No argument from me on that. He later calls this the true principle of parity. Structurally, Supreme Court and inferior federal judges are all Article 3 officers. That means the ordinary United States district courts are Article 3 courts, not Article 1 courts. Where I think your reasoning is picking up something important is here. Congress does create the lower federal courts. That is absolutely right. Unlike the Supreme Court, which the Constitution itself requires, Congress decides whether and how many inferior federal judges to establish. Amar says precisely that. And Amar makes another important distinction. The Supreme Court derives its jurisdiction in significant respects directly from the Constitution, whereas Congress confers statutory jurisdiction upon lower federal courts. So there is a real distinction. Supreme Court, constitutionally required. Certain jurisdictions come directly from Article 3. Original/appellate division is constitutionally specified. U.S. district courts, created by Congress. Their subject matter jurisdiction is largely statutory, but they exercise Article 3 judicial power when properly constituted as Article 3 courts. This is the qualifier right here, where the deception lies. That's where the deception, right there. When properly constituted, what does that mean? The last point is where I would modify your conclusion. Well, I just pointed it out. Article 1 creation does not necessarily mean Article 1 tribunal. Congress' legislative power is involved in establishing the institutional machinery, but the court's constitutional character depends on the office and power created. Okay, I agree with all that. Okay, let me get down here where I asked him again. I said inferior Article 3 courts are operating in a ministerial capacity when enforcing statutes. I would sharpen that proposition. An Article 3 court may perform ministerial acts, but adjudicating and applying a federal statute in a genuine case or controversy is not, by that fact alone, a ministerial function. Akhil Amar's article actually draws the opposite structural conclusion. His coextensiveness principle is that when Congress legislates within its constitutional authority, the executive executes the law and the federal judiciary adjudicates disputes arising under it. He describes those as coordinate but distinct functions. The distinction becomes clearer when we use the technical meaning of ministerial. A ministerial duty is essentially one where the law has already determined the result and the officer has no remaining discretion or exercise of judgment. The Supreme Court has used that distinction in mandamus cases when an official merely has to perform a fixed legal duty. The act can properly be called ministerial. By contrast, when an Article 3 judge must decide what a statute means, okay, got it, whether it constitutionally applies, what facts have been established, whether jurisdiction exists, whether one party has violated the law, what remedy follows, and then enter a binding final judgment. That is judicial power, even though Congress supplied the statutory rule of decision. Article 3 itself extends the judicial power to cases arising under the Constitution, laws, and treaties of the United States. However, I got all of that. Genuine case or controversy is vested in Article 3. I'm not making that argument, and you appear to be doing the same thing they do to obfuscate the point. The point is separation of powers does not allow Congress to exercise the judicial function, and when enforcing statutes for Congress, the courts are not operating in a judicial capacity. That is settled law. I understand the distinction you are drawing now, and on the narrower proposition, you have substantial Supreme Court authority behind you. The part I would still refine is the phrase enforcing statutes, because that can describe two constitutionally different activities. The settled separation of power principle is this: Congress cannot take a function that belongs to itself or the executive, assign that non-judicial function to an Article 3 court, and thereby convert it into a judicial power. An Article 3 tribunal may exercise only judicial power when acting as a court. That principle appears very early in the Republic, and I'm in perfect alignment with that. Hayborn's case is extraordinarily strong on your point. The report states the principle directly. It is not in the power of Congress to assign to the judiciary any but judicial duties. That's exactly correct. More importantly, the circuit judges explained that Congress could not constitutionally assign them duties that were not properly judicial and performed in a judicial manner. Because their pension determinations were subject to revision by the Secretary of War and ultimately the legislature, they concluded they could not perform the assignment as a court. Some of them were willing to perform it instead as commissioners. That is essentially the capacity distinction you've been pressing. My chat, we've been talking about this for a long time. You can see I've been going back and forth with it. The reason I'm reading this in this way, because I don't want y'all to be thinking ChatGPT is just controlling me or something like that. No, AI ain't controlling me. I understand how it works. I understand why it draws certain conclusions the way that it does. So when you understand all that, you got to know how to use it as a tool. And, that's what I'm doing right now. I'm breaking down that guy's white paper, that law review. I'm just breaking it down on the points. I just wanted to contrast what he was saying with what I'm saying. My ChatGPT already has all the information on my position. So I just asked it to juxtapose it with this law review. And do we kind of see eye to eye on some points? And we saw eye to eye on some points. That's my only contention that I'm making. And that right there should, and why am I doing that? To show that I'm not crazy, that you have a Yale law professor that sees some of the same things that I see and has some of the same questions that I have. That's the only thing I'm saying. And I think there's a reason. I think, well, why would be the reason that they would want to hide this? Because of the money. Because of the money. Because of the money. Hey, look. I got to leave some. I can't give all of my, I can't put everything out there. You know, I can't put everything out there. I gotta do some more studying. There's a lot more research that I have to do on this particular point. Because I'm weighing both sides. You know, I look at both. I always try to be objective too. But just something don't sit right with that separation of powers to me. It's just not sitting right. You know, it's just in that area. That separation of powers is just not sitting right with me. So that's what I'm just kind of like, And notice when the Pennsylvania Circuit Judge says in Hayborn, the judicial should be distinct from and independent of the legislative department. And the people place judicial power not in Congress, but in courts. They then said the pension business is not a judicial nature and therefore form no part of the Article 3 power vested in the courts. Obviously, the pension is solely under the purview of Article 1. They got the right to regulate commerce and all of that. So that's appropriate. The courts are doing what they're supposed to do in that situation. That's not a part of the judicial Article 3 power, something that falls within the cognizance of Congress. And that's my argument. When I look at an indictment, a federal indictment, I see every time violated interstate commerce, and all these federal indictments, drugs, whatever it is, violated interstate commerce. Well, that falls under the Congress's purview. Article 1, Section 8, Clause 3, they have the right to regulate commerce. So that's the jurisdictional element that they placed in that indictment. So it falls under their cognizance. So I'm not saying they're doing anything wrong. So I see how everything is operating. However, what is the true nature of the proceeding if it's not judicial? We just got some questions. I just got a few questions. These questions got to lead. So even the Chat GPT can't lead me off the trail, because when you stick to the principles, you'll even notice that I even feel like somewhere they have already, before they introduce these AIs to us, they already put all this stuff in there. Now, if they come walking down this road, sniffing around, you tell them this. You know what I'm saying? I'm like, nah, Chat. Let's get back onto this principle of separation of powers. You have to keep bringing it back to that. And it'll try to phrase something in a way that tries to obfuscate the real issue. But you can't let it, whoa, no. And I'm like, you know what? Somebody trained you to do this. Because you see the attorneys doing the same thing. And I know it's pulling from their sources, but, that's what I see, So if anybody, that's the point that's where I'm at. That's what I've been always looking at. When I ask you when you're asking what jurisdiction the court is operating under, it's never to try to say, oh, you need to dismiss the case immediately or something like that. That's not the reason for it. That's not the reason you're asking that question. You're trying to determine if it's civil or criminal. That's what that's what I'm looking at. I'm trying to determine if it's civil or criminal. What is the true nature of it? That's what I want to know. And the Sixth Amendment says I got the right to know that. So that's where I'm at. That's why I asked the question. I don't know why y'all asked the question. I don't know why you do it, but Fieria makes your two capacities points even clearer. In United States versus Fieria, Congress assigned a statutory claims function to a federal district judge, but the determination was ultimately transmitted to an executive officer rather than operating as an independent final Article 3 judgment. The historical treatment of Fieria recognizes that the judge was essentially acting because Congress had designated the person holding the judicial office rather than because an Article 3 court was exercising constitutional judicial power. I mean, everything is consistent with what I'm saying. I could be wrong. I don't think that I am, though. Said, peace to all your studies. Have you found the government not to be corrupt at all? Well, I'm not saying that there aren't corrupt people in government. Obviously that there are. I mean, we've had all kinds of scandals and things that happen. And yes, I've seen they're human beings, all right? So yeah, there are corrupt people in there. Yeah, there are. However, are the laws corrupt? No. You know, when the way that I see that the laws are drafted, no, there's nothing wrong. These people follow principles of law when they draft all of this out. They're very knowledgeable in what they're doing, and they are doing it correctly. Now, do they try to? Obviously, there are laws that get passed that are unconstitutional because, as Scalia said, we ignore the unconstitutional parts. And you heard that senator say what we can get away with in the courts. That's ultimately up to the people. We have to police that by challenging the constitutionality of something. But you have to be educated enough to do that. You have to have a good, you have to understand these things that I'm talking about right now. You can't be just like challenging something just because you don't like how it went. You're never going to win anything with that. Nothing with that. But it would help if you studied some principles of law, the principles that underlie the Constitution, actually read the Constitution itself, understand its application, understand its relationship with the states, understand where its position rests in public law and how that is distinct from private law. Then you'll have a framework, I think, that you could probably operate from. Sixth Amendment clearly says it applies to criminal proceedings. Therefore, you should know it is a criminal case without asking. Yeah, but criminal was also civil in nature, too. That was my point. That was why I was reading you about the penal action earlier. And then that's why when you study admiralty had a criminal aspect to it, too, but it was civil. The civil machinery used to be used to exact punishment. So the United States has a history of debtors' prisons and using the civil machinery. So punishment can be exacted in a criminal nature through the machinery of the civil. So that's what I am. Seventh Amendment applies to civil cases. Okay. I agree with you there. I'm trying to find out I'm trying to get to the money. Are we headed toward to the money? I want to get to the money. I want to know if they bonding prisoners and selling them. Because the 13th Amendment protects slavery. So when you get arrested, you are in slavery. All it says was you're not permitted to call us slaves anymore. So that's why they use other terms. The only thing the government is not permitted to do is to use the word slave. They cannot use that word. The institution itself, what they call the peculiar institution, is alive and well. Okay? But they're just not allowed to use this word slave. All right, so they use inmate, taxpayer, employee. It's probably, a lot of different terms now they can use in place of that. However, in the reading of the 13th Amendment, it is readily apparent that when you get convicted of a crime, you can be put into slavery. And when I study the institution of slavery and how slaves were sold, they were sold through bonds, which is evidence of a debt, which can be securitized, as long as it can collateral supporting it. Labor can be used as collateral. Hell, the United States borrows trillions of dollars based off the future labor of the American people. I just got some questions. See, the things that I'm saying make sense. Now, would my premise be off? Yeah. Is that how it really is? I don't know. But these questions make sense, and they're legitimate questions. Based off of what I'm studying here, I think that they're legitimate questions. The money is your false premise. Okay? I know that's what you was going to say. I know you was going to say that. I'm cool with that. That's my false premise. Okay. So that's going to be where I'm going to come hard at. I'm going to come hard. I'm going to come hard right there. I'm going to come hard right there, all right? The money. That's my false premise. I know that's a difficult, you know what? And you can say that with your chest out because that is something difficult for me to prove. It is. But I'll take the challenge. I'll take the challenge. This is the distinction I was not given enough weight to before. Judge does not equal court in every act the judge performs. That's absolutely correct. See how you had it? Man, this chat right here, what it's saying right now, this is exactly what I'm talking about right here. In United States versus Ferreira, I guess, Congress assigned a statutory claim function to a federal district judge, but the determination was ultimately transmitted to an executive officer rather than operating as an independent final Article III judgment. The historical treatment of Fiera recognizes that the judge was essentially acting because Congress had designated the person holding the judicial office rather than because an Article III court was exercising constitutional judicial power. That is the distinction I was not given enough weight to before. Judge does not equal court in every act the judge performs. That's what he was trying to tell me earlier, that these are Article III judges with protection from salary diminution, and they've been put in place by the Senate. Yeah, I don't disagree with any of that, but that doesn't make it an Article III court, just because the judge is Article III. A person possessing an Article III commission can potentially perform a non-judicial function in another legally authorized capacity. That does not transform the non-judicial function into an Article III judicial power, which is what I'm saying, which is my position. It says it's impossible for you to prove, and I can show it. Okay, hey, listen, I know you're going to show it. Let me get on it right now. I haven't really, now you're going to make me do some research. Because I got sources to go to, but I ain't looked into them strong. But if that's your position, right now, what I've been doing is do I have a basis for even looking in that direction, which I think that I do. Now, the reason, why is that being shielded from the people? Well, it's because of the money. And obviously, y'all not going to admit that, because you be admitting to engaging into some sort of slave trade. So no, you're not going to admit that. You would never admit that. Y'all gonna stand on that. I got it. I don't expect you to do nothing else, because of the implications of what the truth will reveal. I'm just saying. Is the information for citizens on a ship participated in commerce come out of her, my people? I don't know about all that, but I just think that it's interesting. I looked at some of the procedural mechanisms utilized in the criminal courts, and compared that to admiralty, and I found out that a lot of the procedural machinery of the admiralty was borrowed and is being utilized in the statutory jurisdiction. Now, I'm not saying it's an admiralty court. I'm just saying that those mechanisms, because they were able to facilitate commerce better than the common law, because the common law was too rigid and I know we have different definitions of common law. Common law is case law, judge-made law, the decisions of the court, stare decisis. I get it. But I'm just saying, in looking at all of this and just studying the history of the Commerce Court and the debtors' prisons and admiralty, and looking at and studying the ancient common law and the admiralty, those two different courts, when they were vying for power with each other over in England. And, I've kind of looked at a lot of things, and I can see, the admiralty deals a lot with bonds. And, the court system has the court registry investment system. I know they're applying CUSIP numbers, which are tracking numbers for securities on these cases. I'm just saying. I thought like you until I went to law school. Yeah, that might have been the problem. You went to law school. I was reading this book. I was reading this book, Juan. It's called 1L. 1L. The author's name is Scott Turow. He graduated from Harvard. I think if I read correctly in this book, he kind of like finished like 6th or 7th in his class or something like that. But I read that book. That was a very good book, and the book was about 1L is a first-year law student. And so it was kind of like a documentary of his experience as a first-year law student at Harvard. And he was just saying some interesting things. We made up your admiralty stuff back in the 60s when I was in the Posse Comitatus. Well, look, I'm not saying it's admiralty. I'm not saying it's admiralty. I'm not saying that at all. I'm not calling it admiralty. I'm saying it borrows some of the procedural mechanisms of admiralty because they're very similar, like when you arrest a person to initiate, to force an appearance, making them provide a bond, all of these things, all of these are in admiralty as well. So that's all I'm saying. I'm not saying it is admiralty. However, they did borrow some mechanisms from the admiralty without a doubt. There are a lot of procedural mechanisms that you find in these statutes that exist over in the admiralty. I could take creditor and debtor law. You know, when you're talking about issuing a bond on a replevin bond, you know, they have a lot of things similar to that in the admiralty. Call it anything you want, the maxims don't change. One simple claim on record by a living man changes the dynamic. I don't know about that. I don't know about that. I don't know about that right there. That living man stuff, that I don't subscribe to that. That's not a proper argument. That is some sovereign citizen type of stuff. That's not a recognition of understanding what a person is and what it serves at. You know, this person thing is a very important thing that people need to get a good understanding of, because this straw man theory that they give you, no, that's not how it is. It's not, I'm the real living soul. Need to stop coming into court doing that. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may. Yeah, if you go to, what is dude? Let me show you this case right here. This dude, Valiant Liberty, he found something real good. I don't know. You know what? I haven't had time to research this. I don't know if I should even talk about this right now, because I need to make sure I verify all these sites. Yeah, I think I'm going to verify these sites before I do that. I'll do that on another show. I'll make sure I've got everything verified, so before I start talking to all of y'all, I got to read it first. I don't like talking about something I haven't read. I don't just want to read the site. I want to actually have read the case and then make sure I got it in its proper context, what it's talking about. Admiralty got its stuff from tort, civil law. Admiralty, the word admiralty comes from the word emir. It's actually a Moorish term. The word admiral. It literally is a Moorish term from where it comes. They're the first ones. They were the word emir. And I don't know, you said it came from the civil law of tort? That might be true. I can't argue with you on that. Tort predates admiralty law. I agree with that. Tort is a private injury, so yes, it does. Yeah, I know. It's private injury. So, yeah, I agree with that 100%. It does precede probably the admiralty. I can just basic common sense that the law of the sea had to come after the law of the land, or laws like that. But I want to read this right here because it talks about how the admiralty came upon the land. This is these judges talking about it in the regulation of commerce, and I think that's what everybody's trying to figure out. Juan, they're trying to figure out what is this thing y'all call statutory jurisdiction. I understand that the statutes are lawful. I don't make that argument at all. I think that there is a problem, though, with what happened with the judiciary, with the taking of the gold and silver. And that was evident in that case that was up in Minnesota where that judge, he ruled against that bank because he said that Federal Reserve notes weren't real money. That right there lets me understand that there was a time the justices thought like that. Okay, and he got found dead 6 months later. I'm reading about some of these senators. They didn't read H.R. 192 before they signed it in the law, before they passed it. And some of them, which were 33-degree Masons, and the ones who spoke out against it ended up dead. See, it's things like that, Juan, that lets me know that there is somebody somewhere, because this conspiracy goes back a long way. It ain't just something they're just doing right now. It's been done like in stages, all throughout history. And you can go back into the 1930s and you're just looking at a certain stage. And then when you bring it up to today, you say, yeah, I see what they're doing. I see why they're trying to get everybody, now they're trying to all of a sudden effeminize all the men. This is part of the plan. Everything, destroy the family. They following their plan. You say, look, we got to get all these people separated. We can't have no families. We can't have all of this because somebody is behind the scenes pushing the world in a certain direction they want it to go. Now, that right there I have a problem with because we're supposed to be free will beings, and I don't like anybody, just controlling me like that. So that is the question I think a lot of people won't answer. Okay, I have a God-given right to freedom. How can I exit the matrix? What is the line? What is the demarcation line that separates public regulated authority from private rights? That's where people are trying to find out. Like, damn, you're making us pay property taxes so we can't own the land. How does that happen? You know what I'm saying? I think that there is some sort of constitutional violation in that. I really do. I think that, pay property taxes. I don't pay my property tax. You can take my land. Something doesn't sit right. That doesn't sound like something the people would vote for. That doesn't sound like something. It says, our founders designed the U.S. to operate under statutory law. Want the people to be able to hire. Okay, we got to define the U.S. because, remember, you want me to give you that case where it gives you the 3 definitions of the United States when it's operating in its territorial capacity versus its nationwide capacity versus its international capacity. The Supreme Court has identified that there are 3 different senses the word United States can be used in. So the Constitution is part of public law. So it creates the government and defines what the limits of their authority is, and it operates in public law. So I understand that it has a certain area it operates in. So when you say United States, okay, I understand that. But it has a certain jurisdiction it operates in. It doesn't just have this wide embracing authority like everybody likes to pretend. I don't know, what are the limits? I guess the question I'm asking, I might not be saying it right. What are the limits of government? We have a limited government. What are the limits? Because we can't find one with commerce. You done admitted that yourself. We can't find one with commerce. Okay, you know the court. Okay, you know the case, all right? So we can't find one in commerce. What are the limits of government? I don't know. I don't think nobody else can tell me that either, not even you. I don't think you can tell me clearly, definitively, what are the limits of the government. And one of the principles of the Constitution is limited government. I'm just saying. It had to make sense. It's not making sense. We do have a government. Please don't come in here with that sovereign citizenship. All right? We have a government. Don't come in here with that. Don't come in here with that. Let me say you this. You have accepted benefits and privileges from this government. Y'all argue for it. That's the whole reason H.R. 192 of June 5th, 1933 came about. It was the citizens that went into the Great Depression because they got in a state of dependency. Instead of staying on their land, growing their own food, instead of going to these cities, all right, you went to these cities. America used to be an agricultural country where you educated your own children, you grew your own food, and you built your own damn house. What happened? You wanted convenience. And if you want convenience, you're going to get taxed for that. So don't be calling the government corrupt. With your lazy ass. What you trying to build yourself? The government is a reflection of the people. You better look in the mirror. The government is a reflection of the people. Look at what the people are doing. Look at the debauchery, the immorality. You can't keep your marriages together. You ain't raising your kids. A lot of y'all taking drugs like 9,000, polluting your temple. You ain't following nothing under the Bible in any shape, form, or fashion, or nothing like that whatsoever. What are you talking about? How's the government is supposed to be when the people are corrupt. What's going on in the United States of America is worse than Sodom and Gomorrah. You can read Sodom and Gomorrah and read that and say, man, this ain't shit. You can read about Sodom and Gomorrah like, that ain't shit. God destroyed the world for that. We got way worse stuff going on right now, man. We got people can't figure out what their gender is. And now right now, the biggest argument right now in the news is, can a transgender man play in the WNBA? And I think he should be, because I think the women need a wake-up call. I think we need a hard reset button on feminism. I really do. So I think, hey, let them do it. This is what you got going on in the world today. With the right info, Yusuf would make a kick-ass constitutional law attorney. I appreciate that, Juan. I appreciate that. We're going to talk, man. We're going to talk. I'm going to talk to you. I'm not saying I'm 100% right. And I think that I do think I would have made a good attorney, because I like this. You know what I'm saying? I like it. It's like it doesn't bore me. You know, it excites me. You know, I like the whole thing about it, you know. So, yeah, I'm pretty sure, too. I think it was something I was probably meant to do. I probably, you know, I said I was going to do it when I was younger, but I definitely enjoy it because I like words and, you know, and things like that. That's always been my thing, reading and things like that. So in reading this, you can see the intelligence behind it. You can see the structure. You can see how the reasoning skills that it requires. And, you know, and then also, you know, the structure of it, you know, how judges make determinations on things, you know, like somebody's calling something corrupt. Like I've read cases with my students and I'm saying, is the judge being corrupt here? And they say no, because once it's been explained to them and they can understand it, the principle behind it, especially if they understand the principle behind it, and they can see the clear violation of the principle in real time. And then they say to themselves, like, look, I can't, he's wrong. I can't go with that. You know, the judge is right, you know? And then you come and try to bring that out here, everybody gonna say, you know, the government has turned you. The government got to you, Yusuf, when the real issue, they haven't read anything. They haven't studied any of this stuff, man. They are emotionally bound. This is emotional. The sovereign citizen movement is an emotionally driven movement. It's an emotionally driven movement. It's not an intellectually driven movement. It's emotionally driven. And that is the problem. They think it's being intellectually driven because they'll pull a citation somewhere and half-ass understand it, or, you know, just do something like that. See here, and, you know, find a statute somewhere. They don't even know what the statute, what it applies to, you know, what it's for, anything like that. They just automatically give it this wide universal application just by the fact they found it. You know, all this kind of stuff. I see what they do. And I understand why y'all call them crazy. And, you know, I understand that. But there are some, I think, there were some people who did come along who were not crazy, who were extremely intelligent, and who were able to perceive certain things. Everybody wasn't crazy now. And I'm standing on their shoulders. I'm standing on their shoulders. Hey, let me get back. All right, y'all. That's it for me today. I appreciate everybody. Like, comment, and subscribe. I hope you were able to garner some nuggets of information from this that could help you out and your research. Hopefully you are researching. Hopefully you're engaged in independent research and you're not in the echo chambers regurgitating slogans that have been circulating for the last 30, 35 years that have almost like a 1% success rate, if that. Like, comment, and subscribe. Peace. I'm out.